inviting me into your lovely programme.
Now, I want to turn on to a development regarding courts in Scotland and how the system there differs to the rest of the UK. It's a topic of much debate. The top law officer there has put forward proposals to change the way evidence in rape trials is presented. Lord Advocate Dorothy Bain believes distress should be used as a valid form of evidence, something which is already possible in England and Wales, but not in Scotland. For some, they hope that this could give more cases their chance to get to court. But for others, there are questions around whether this could lead to wrongful convictions and if the already struggling system can cope with this new demand. Sandy Brindley is Chief Executive of the Rape Crisis Scotland and welcomes these changes. Thomas Leonard Ross, KC, is a serious crimes barrister and thinks the system should stay the same. Welcome to both of you. Thomas, let me begin with you. The reason the system in Scotland is different is because of something called corroboration. Can you explain briefly what this is and how it applies to rape cases?
Well, the position in short is that in Scotland, the material facts in the case, the important facts required to be proved by evidence from at least two sources. And in a rape prosecution, one of the material facts is that there has been intercourse between the parties. I'll use that term. And therefore, there has to be two sources. Often in relation to the cases which come to court presently, there will be the complainer's account supported by perhaps DNA evidence, or the complainer's account supported by the fact that the accused says when interviewed that he did have intercourse with the female, but it was consensual. So those are the cases which come to court now. The problem, as the Lord Advocate sees it, is that in the cases where there is neither scientific support nor an admission, then there will be insufficient evidence of intercourse, and in those circumstances the case can't even get off the ground. So whereas if there was two sources of evidence of intercourse, then the fact that the complainer was seen to be distressed could provide evidence of the next stage, namely that it happened without her consent. But in Scotland, until now, they have stopped short of allowing distress to corroborate the fact of the intercourse.
I understand. So it's very much interconnected in that way. Sandy, yes. What do you think would happen if distress could be used as evidence? What would it mean exactly in court?
What we know is, as Tommy's outlined, is that this can act as a real barrier to cases getting to court. Often because it's quite natural for people to delay reporting rape, for example, because they're shocked or they're not sure whether or not they want to report. So delayed reporting is really common, but what that can mean is the reporting is too late for forensic evidence to be gathered, so it can be very, very difficult to then corroborate penetration, and this can act as an absolute barrier to cases getting to court. And it can particularly impact historic child abuse cases where there's very unlikely to be any forensic evidence. So there's been a number of survivors have spoken out really powerfully, including a group called Speak Out Survivors, to make the case that if they'd been abused south of the border, their case could have got into court. But because they were sexually abused in Scotland, there's no possibility of their case getting to court. And I think that can feel like an absolute injustice. But I think it's important to be clear that this is about removing a barrier for cases to get to court. It doesn't mean that we're going to see necessarily an increase in convictions.
Okay, that's interesting, and I'll come to that in just a moment. But I think my listener might be thinking, Thomas, what would evidence of distress be? How would you quantify that or qualify that?
Well, the case which the Lord Advocate has brought is based on a real trial which happened in Aberdeen High Court, where the accused was acquitted. And the circumstances seem to be that the couple were in a flat, that the girl alleged that she was raped in the flat. Her boyfriend came to the door and she went to the door in a distressed condition. So she was upset, tearful, I think, and immediately complained to him that she had been raped. So that's a real life example. And what happened in that case was that the trial judge told the jury that that could not be used as evidence of penetration. He was acquitted. Nobody will ever know if that's the reason why he was acquitted, but it gave the Lord Advocate the opportunity to bring a reference to the appeal court essentially to say that the law should, if that is the law, then the law should be changed. And it won't affect the acquittal, but it will affect the law going forward.
I think the first thing I think of with that evidence of distress, does everybody consider distress the same thing? Does everybody act in the same way, even though they are distressed? I mean, being tearful might be something that is commonly thought of, but of course people can have so many reactions, I'm sure, after an incident of like that which was alleged. Thomas, do you think this should go ahead?
I think it will go ahead. I can see the argument for it. I mean, I've read the Lord Advocate's legal submissions and they're very good. In fact, the corroboration doctrines are practically worth nothing in sexual cases. They've stretched it to the point where it really provides very little by way of a protection already. This will stretch it further. So, I think it's inevitable. I can see the access to judgment argument, access to justice argument. I mean, I think it will have resource implications. It's already 2.5 years in Scotland, sometimes from the incident to the trial, and this will generate a lot more cases. But I'm not saying that's a good argument for denying people access to justice. I'm really just pointing out that it will have practical consequences.
But as a barrister, do you have any concerns?
I don't have any concerns, no. I don't. I mean, the reason that we've got to this position is that some people occasionally make false complaints, not suggesting it's a huge number, but some people still do it. You had a very widely reported case in Barrow-in-Furness recently where a female made false complaints against a huge number of people. And that's why we have corroboration. That's why every legal system has checks upon an individual witness's evidence. So I'm a bit concerned that the last of the checks will be removed. But I can also open my mind to see the competing argument that if it means that a genuine complainer cannot even get to court, then I can see that argument too.
Sandy, has it made a difference to the number of rape convictions in England and Wales that has used evidence of distress?
No, I mean, I think that's a really interesting point, is that the situation in England and Wales is at least as bad, if not worse, than it is in Scotland in relation to the very small number of reported rapes that get to court. So I think it is important to say that while this is a positive development for us in Scotland, it is not the whole part of the picture in terms of what needs to happen to improve justice responses to rape. So the Scottish Government introduced recently to the Scottish Parliament a bill which is looking at introducing some quite substantial reforms to how justice responds to rape in Scotland, including the introduction of specialist courts for sexual offences, legal representation for complainers in certain circumstances, and also piloting rape and attempted rape cases in front of a judge alone rather than a jury. So I think while this Lord Advocate's reference is important, although we do have some concerns, as you've illustrated, about how distress is conceived of, because people do respond really differently to rape. But it's positive, but it has to be seen, I think, in a wider context of the change that's needed.
Let me turn back to you, Thomas. Cases like this to defend, can you explain what that's like? And would it be more difficult with this law change, or indeed put lawyers off from taking cases like this?
I can answer that question in this way. I've already told all the solicitors who give me cases, I'm not doing any more sex cases.
Why?
I'm using to take them on. Well, a combination of factors has created quite a hostile atmosphere towards those who defend people in rape cases. And, it's causing quite serious distress to the advocates who take them on in Scotland. There's a whole variety of obstructions whereby you're restricted in the questions that you can ask potential victims. In addition, there have been a number of developments where people have cross-examined complainers in actual real-life cases, and the cross-examination has been put on Twitter, for example, which has led to the advocate's family being personally abused for his conduct. These are all factors which make people like me think it's not worth it. It's not worth doing it any longer.
But you don't think that there's a duty to that alleged accuser, the person who's accused?
There's 450 advocates. I'm not worried that anybody's going to be unrepresented.
But by who is the question?
Well, every year, we're having a dozen people coming out qualifying as advocates. What I'm saying is we need to be careful about it, because there's no doubt that the people who are defending back-to-back sex cases are considering their options. They're leaving the profession. They're applying for jobs as sheriffs, as tribunal judges, that kind of thing. There's a drain because this hostile atmosphere has been created so far as people who defend sex cases are concerned. There's no lobby. There's no rapist lobby,
I have to leave it there. Really interesting, though. We'll look into that further. Thomas Leonard Ross, KC, and Sandy Brindley, thank you both so much. And thanks to you for joining me on Woman's Hour. I'll see you Monday. That's all for today's Woman's Hour. Join us again next time.
Hello, I'm Brian Cox.
I'm Robin Ince.
Welcome to this very